Ladies and gentlemen, gentlemen and ladies, I'm getting this little error message. It's saying that my Microsoft Office ain't registered. So give me a second. I'm going to take care of that, and then we're going to get to the crux of the matter. I'm going to show y'all how to do the same thing. I went to this video, permanently activate Microsoft Office 2016 Pro Plus without any software or product key. And the video starts off at the beginning, but I have two windows open because this one is a protective software. Uh-oh, gotta stop that because it'll keep trying to type, and I don't want it to type. Okay, I'm gonna click this. It's not a product key, okay? It's actually a code. And so I'm gonna click the code. Yeah, we gonna do this. Tick tock, tick tock, tick tock, tick tock, tick tock. Now, let's go back to the video and see what it says. See, it says where to go in the office, where to click on account. It's gonna give us action required. And then what are we gonna do next, young man? I hate these videos that don't talk, but it says where to put that in. And this stands for itty bitty tiny link. Let me see if that's the link that I put in, because I don't know, but I do believe it is, because yeah, Office 2016 text. Then wait, hold on a minute, something ain't right. Hold on, stop it. Let's do that again. Let's copy. And let's go back here, because this took me to a download. So, oh, that's one of them downloads. I apologize, y'all. I should know better. I really should. Okay, this took me here. I don't need that. I need this. Okay, let's do that again. Tick tock, tick tock. This is what I need. Don't know why it took me there, so I'm going to have to delete that other junk. Oh, that's because it was the wrong page. Alright, copy. I know what that is. That was taking me to an actual link, so now I'm going to have to delete that junk. Alright, you just go to this page and you copy this text. Now, we're going to follow what he said. It says select all and copy. That's what we did. Let's see if this worked. Now, alright, so let's do that because we got to create a new text document. I understand. I get it. I don't need this. I was going in through something else because I have the Microsoft Office product and I do have an activator, but I'm not going to use the KMS activator. I'm going to use this gentleman's way. On my desktop, I'm going to right click, going to go new. It's going to ask me about a text document. I'm going to do text document and I'm going to say activation. So Microsoft Office activation code. Then I'm going to open up. Oh, don't run from me. They're always running from me. I be trying to catch up, but I can't catch. And I don't know which way is up. So I can't catch up because I don't have no fries. Okay, now, because we copied and pasted the text, we're going to close this after hitting save. Because I don't need to keep it open. It's already copied and pasted and it's on my desktop. Now, this video isn't about this, but this is for some of you who don't have Microsoft Office. Showing you how you get it. Just go to YouTube. People were putting up videos on how you can get certain software. Well, I want to know how to get this, then type it in YouTube. Sorry. See? And then he's going to say save. Oh, it's saving as Office CMD. I messed up. So, watch this. .cmd. Now watch this. Watch this. I was skipping ahead. I do like y'all do. When y'all want to skip ahead, y'all think y'all know what I'm going to talk about, and then y'all get surprised because it ain't what y'all thought. And, well, anyway, we're going to do rename, and this is the extension. We're going to change the extension to command, CMD. That's what CMD stands for, command. This is Tallahassee, Fort Worth to command. Tallahassee? Remember Richard Little? Y'all don't know Richard Little. Many of y'all don't know who Richard Little is. Richard Little is a comedian. And Richard Little is a phenomenal comedian. He's also an impressionist. He impresses upon us the different voices of many actors, and he's extremely excellent. Not good, he is excellent. Well, Tallahassee comes from the President Rap. He literally did a song called President Rap, and it was him acting like Ronald Reagan. TikTok. Okay, now it's saved. Then he's going to right click and run as administrator. I told you he was going to do that. Hold on. Let me see if I can run as administrator, because I just ran a different script. But let's see if we can run this as administrator. If it'll work. Run as administrator. TikTok. The other one I have is called One Click. And that's what I was attempting to run as administrator. Tick-tock, 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 tick-tock. It says it can't find it on my system. That's because I have 360. So I have PowerPoint and all of those things. Come on now. We got people who are waiting. That's 6 minutes worth of waiting. We can't afford to be sitting up here waiting for you all day. Oh, I've seen that line before. That line just keeps popping up, just line. But I crossed the line because me and Johnny Cash, we go way back. Oh, the other one did the same thing. See, this means I'm going to have to activate the KMS because KMS, yes, kiss my signal script. Hey, product activation successful. Look at that. Would you like to visit? Nah, bro, I'm not going to visit you today. Did you see that? That's how simple it is, y'all. I didn't know it was going to be that simple. Let's see if we get the Microsoft, because I reloaded something on the computer and I got rid of a previous virus scanner, and then it just took away my Microsoft activation. And so it took away my Microsoft activation, y'all. And so when I started up, it kept saying activate, and I'm like Wonder Twin Powers, and I said, no, I don't feel like activating. And so, you go through that all the time. I go through that all the time. So I'm going to shut up now and just open Microsoft, because that's what this is about. And I'm going to make several copies of this code. That brother is all right. They come up with a code to get past Microsoft and this stupidity. Man, that brother's all right. Oh, no more activation issues. Look at that. EEON, there you go. All right, now let's see. No, we're not doing that one. We're not doing that one. A bill of equity for the enforcement of a contract after an award. This one right here. This is what we want to bring to your attention today. The video I'm doing after this is also just as important. Ladies and gentlemen, for those of you who get an arbitration award, the issue is not, now of course you're going to enforce the award. That's necessary. You're going to get the confirmation of the arbitration award, but again, you have to file into the court for that, and they're going to charge you the full filing fee because they're going to treat that as a case. You know what? Ladies and gentlemen, if they want to treat it as a case, then ask for a jury trial. Lord have mercy. God, I am a genius. I don't know, ladies and gentlemen, I don't know why it happens this way. You guys don't understand what I just said. Those who have done arbitrations know that in order for you to get an arbitration approved or disapproved, you have to, sorry, I am looking at some change that was given to me yesterday. See, I always tell the person, no pennies. And so I thought the person gave me pennies, and I was going to go back up to that store and say, what the, you give me pennies for when I told you I don't want no pennies? But it was just a dirty nickel. Ladies and gentlemen, regarding arbitration, you have to go into the court. And when you go into the court, you have to file for your motion to confirm, and it is filed like any other civil lawsuit. However, you guys are leaving it up to the judge to get your arbitrations confirmed. No, you ask for a jury trial to get your arbitration confirmed. You don't leave it up to the judge to deny or do anything. You ask for a jury trial in your motion to confirm because it is a lawsuit. and you can get the contract enforced at the same time. Now, look, I just came up with this, so I haven't processed it yet, but you don't know what the issue is. See, we've been trying to figure out how to get around the courts ignoring the Federal Arbitration Act and denying our motions to confirm. Well, the way you get around that in getting your motion confirmed, pay attention, because many of you are not listening. To get around the court thinking that it has jurisdiction, you simply ask for a jury trial in your motion to confirm. Now, here is the thing. You ask for a jury trial in your motion to confirm. What's the problem with asking for a jury trial? Well, see, they can't say that it's frivolous, meritless, or anything else. And by asking for a jury trial, you take away from the court thinking it has the ability to control anything. But you also get the enforcement of the contract. Now, the judge at this point can't say whether the contract is valid. They can't say whether or not the contract is binding. They can't say anything because they have no control. You are not going in there to get a determination as to the validity of your contract. That's already been done by the arbitrator. The arbitrator's award is prima facie evidence that the arbitrator has determined, as the Supreme Court says they have the authority and jurisdiction to do, that your contract is binding. And as long as the arbitrator has determined that your contract is binding, the courts have nothing to say in the matter. Supreme Court said that, not me. Go back and watch the other videos. See, this is what happens. Okay? Now, ladies and gentlemen, a lot of you, like the person who I'm looking at right now, it says, I have done some reading on the program and I do not have $3,000 up front to pay. Excuse me, ladies and gentlemen, let me explain to you guys. There is a particular issue for all of you to know. The person who wrote that is out of their mother mind. That's a person sending me a text through GLIP. Not through GLIP, through the Google Voice number that's online. Ladies and gentlemen, I don't charge nobody $3,000 for nothing. Go back and look. You don't ever see me telling you, oh, it's going to cost you $85 billion. It don't happen that way. Okay? It doesn't happen that way because that's not the way I operate. That's not the way I roll. Okay? It just don't happen that way. All right. And those people don't get responded to because that means that they didn't pay attention to the information in the first place. All right. Like I said, just the idea that I just came up with, because we've been trying to figure out how to get around the courts just ignoring somebody's motion to compel, not compel arbitration, but motion to enforce the arbitration award and to confirm it. So the way we get around that is because they're making us file as if it's a lawsuit. Well, if you're going to pay the full fee for a lawsuit, you might as well put on there jury trial demand. Take the power out of the judge's hands. Now, they can't conduct it like a regular jury trial. The issue here, the only thing for the jury to decide is the confirmation of the award. And here's the thing. They must decide it in accordance with the FAA. So demand that the jury decide whether or not the arbitration award is to be confirmed according to the FAA. That's it. And the FAA has some strict guidelines on what the court can and cannot do. And it doesn't say, pay attention, does not restrict you from having a jury trial, but it says you must go in accord with the way motions are filed. Well, what the courts have done, saying if you're going to come for a confirmation of arbitration award, well, we're going to charge you the full fee for your filing a lawsuit. That's why they took the gentleman's suit and filed it as a habeas corpus for their incarceration issue. It wasn't about their incarceration, it was about the process. Their contract was about the process they were put through. And Congress said it was a binding agreement. Well, they took and they construed it as a habeas corpus. Well, now we do a motion to confirm and we demand a jury trial because you have the right to a jury trial. That's just me coming up with this right now. I haven't given it complete thought because I just came up with I just wrote the mother last night, okay? I just came up with it right now in this conversation with you all. This is how my mind works. So I'll give it some more thought. But for right now, those who know what they're doing, suck on that for a while, okay? And then get back with me. All right, let's get back to the bill in equity for the enforcement of the contract, because that's what we're concerned about, ladies and gentlemen. So after you get your arbitration award confirmed, that's why I came up with the idea about a jury trial. After you get your arbitration award confirmed by an arbitrator, you're going to go into court and you're going to do a bill in equity because you want to be in, pay attention, equity court. So in the county of Sinister, you know, those sinister counties and those sinister courts, equity probate court, in and for the great state of whatever your state is, then you put your receipt number. If you don't already have a case number, leave that blank and then add it later. Receipt number is the case number. Okay, the parties. And then you say to be applied by the court, the clerk of the court. Okay? Or to be supplied, not applied. To be supplied by the clerk of the court if you want to. Then it says name of the party. This is Ronald Heichenberger. Heichenberger? Man, I knew a Heichenberger. I didn't know a Heichenberger. I just took the name and just right off the side of my head. Side of your head? The side of my head, like the side of my neck. The estate of Ronald Heichenberger. Because you're representing the estate. So you put the estate of Ronald Heichenberger and Heichenberger, comma, Ronald as grantor over the estate. So you're coming in both capacities. Ain't that something? Against, not versus, but against, Farmers Forever Liability Corporation. Who's Farmers Forever Liability? Well, everybody's forever liable. So we're just putting that as an example, a sample. So you put the name of the other party there, and then you want to put, if they are a corporation, a statutory creature of the state. They're a creature of the state. They're a corporation, a creature of the state. They've elected to be sued. So you take care of all that. Ain't no immunity. They're a creature of the state. Now, where there is no law, there is equity. Where there is law, equity remains. Equity is always present, is what that's saying. Okay? We approach this body highlighting the fact that an arbitrator has already determined that the contract was valid, that the arbitration agreement embedded within the contract was valid, and strict adherence to the Federal Arbitration Act. Okay? As by law, when a contract has an arbitration clause that requires an arbitrator to determine the validity of the contract, the arbitration clause, the courts have no business, any arbitration clause, the courts have no business in the matter. The courts have no business in the matter for determining whether or not the contract is validity, and or whether or not the arbitration is valid. The courts have no business interfering. That's what the Supreme Court just said. And that the courts must respect the parties' decision in their contracts to delegate the arbitrability question to the arbitration panel. Ladies and gentlemen, the parties have the right to delegate that. Well, each one of our contracts says exactly that. What you all don't know is we received a PDF from PayPal. We'll explain that in another video. But PayPal decided in November. And so we sent them a PDF in November. Well, we attached it to their PDF. But this is PayPal's PDF that they put their policies and their procedures. They've updated it since November, but this is the copy that we received back in November. It even has the date at the top of the instrument, November 13, 2018. This is the copy we received in November, and we responded to it. But what we need to let you know is that this document has an arbitration agreement in it. Okay, now you remember we've been going over arbitration since, well, I've been going over the arbitration stuff since March of last year. When I realized this is what companies do, then I had to start taking care of things. Okay? I had to start taking care of things with this stuff because companies put in arbitration agreements. I had to make sure that I responded to them appropriately. So, on behalf of myself and the organization, okay, so what I wanted to show you is companies. I'm looking for, let's do that, Control F, Arbitration, arbitration. Okay, pay attention. shall be resolved exclusively through final and binding arbitration rather than in court. Okay, ladies and gentlemen, and it talks about the Federal Arbitration Act governs the interpretation and enforcement of this agreement to arbitrate. Pay attention. They put this in their agreement, and it gives you a time to respond. But you don't sign anything. They just notify you and tell you to go to this spot on their website. This is called a unilateral contract. And it's binding. Well, our contracts are just as binding as this. I only pulled this up to show you that there are plenty of examples out there with contracts being enforced that are unilateral contracts such as ours. Now, let's go ahead and continue, shall we? If the arbitration clause clearly and unmistakably delegates the question, gotta answer this, give me 1 second. I apologize, everyone. I was in the midst of having a call with SATCOM and a couple other organizations to make sure everything was running smoothly. We've run into a couple of problems, and so I am the problem solver, and so it took about an hour for that to take place. So now I have to try to remember where I left off. This program, unlike the other, doesn't allow me to go back and see where you left off, what the last conversation, what the last set of words were. And it's okay because of the way we do things. Ladies and gentlemen, when you get the arbitration award, and you have to go in and get the confirmation of the arbitration award, in addition to what we're doing here, you ask for a jury trial. Why do you ask for a jury trial? Because you have to pay the filing fees the same as you would for a jury trial. You have to file the request for a confirmation of arbitration award is considered a lawsuit. Ladies and gentlemen, you don't believe me, but I'm telling you, you're okay with doing that. Do not shy away from doing that. Do not be afraid of doing that. Why? Because the arbitrator has just said that the contract is valid, and the contract has the other party agreeing that they are stopped from challenging your suit. So they can't come in and challenge. They can't come in and oppose. There is no controversy. Oh, Lord, you talk about, sorry, Charlie. That's what we're doing. Okay, now I'm going to continue. Those of you who don't understand, you're going to go back. Like I said, just figured that out. While I was talking and I said it to the other party, I knew that I had to remember, so I'm glad I remembered. A lot going on, everyone. Now, if the arbitration clause clearly and unmistakably delegates the questions of arbitrability, our contracts do, to the arbitration panel, meaning the arbitrator, then these issues are to be decided by the arbitrators and not the court. If the FAA allows the parties to agree by contract to an arbitrator rather than the court, that the arbitrator will resolve the arbitrability question as well as the underlying merits of the dispute. This is what the Supreme Court says. The Supreme Court continued to say the courts are not at liberty, they don't have the freedom, to rewrite the statute passed by Congress and signed by the presidents. That's 2/3 of the federal government. 2/3 majority. This quote may become more relevant if manifest disregard continues to rear its ugly head. We must interpret the FAA as written, and the FAA Federal Arbitration Act in turn requires that we interpret the contract as written. When the parties to a contract delegate the arbitrability question to an arbitrator, the court may not override the contract. This is true even if the court thinks, that is to say, it matters not what the court thinks. What matters is the Federal Arbitration Act and the intentions of Congress. The alleged exception gave a party resisting arbitration an out if it could convince the court that the issue in dispute clearly did not come within the arbitration clause. That out is now gone. Or as Justice Kavanaugh said, in the opinion, that ship has sailed. This ship has sailed? The ship has sailed. You mean they can't use that anymore? They can't use no stupid exception anymore? Nope, that ship has gone bye-bye and it ain't returning back to port. Oh, sorry, Charlie. Oops. All right. That the argument that the arbitration agreement applies to a particular dispute is wholly groundless. That ship has sailed. They can't do it anymore. We may not engraft our own exceptions onto the statutory text. In other words, the courts have been doing this for years. The Supreme Court has just ruled that what they did was unconstitutional, unlawful, without authority, without discretion. And finally, it is not our proper role to redesign the statute. They do it all the time. The courts in their decisions and determinations, i.e. case law, do it all the time. We bring to this court's attention that judicial officers attempt to circumvent the process and overturn precedent without lawful authority. As the Supreme Court has made clear that there is no judicial discretion when it comes to arbitration, where the arbitrator or the question regarding arbitration is part of the contract, whereby the parties agreed. The Supreme Court has just said this is what they do all the time, that the courts ignore this. In this matter, contract number, it was agreed upon by the parties, is binding, irrevocable, self-executing, and coupled with interest. And as noted above, the contract specifically addresses the issues as to questions as to the validity of the contract, that such was only to be determined by the arbitrator, not the court. The arbitrator, in issuing the award, has by such actions provided evidence that the contract is valid, because the arbitrator can only determine the validity of the contract. Well, if they issue an award, they are documenting that the contract is valid. And if the contract is valid, and that means that its terms, conditions, clauses are valid as well, then a party has a right to petition for the enforcement of the contract. That's right. We have the right to have the contract enforced, which is our intent in this instance. See, we're not asking for confirmation. We're asking for enforcement of the contract. This is a bill in equity for enforcement of the contract. The opposing party has waived all rights, defenses, and/or objections, and yet, despite knowledge of these waivers, is attempting to circumvent the process and commit fraud upon the court. We are approaching this body in equity, as equity must render equity. The contract itself stands as an express trust agreement whereby this petitioner is the grantor, trustor, and the opposing party, the trustee. The government agency, special relationship trustee. The value includes the contract, trust agreement, which is property as defined by the Fifth Amendment of the United States Constitution. The contract trust agreement has an end date, is workable, thus satisfying all the prerequisites of an expressing the trust or declaring the trust. We put here expressing the trust. Ladies and gentlemen, let me make sure you understand there are 5 elements to a trust. There must be a grantee, grantor. Okay. Say grantee, grantor, trustee, trustor, 2 different parties. Grantor, trustor, same party. Trustee and grantee, different parties. So those are your 2 elements. There must be a vice and a verse, a pro and a con, a petitioner, a defendant, a respondent, blah, blah, blah. There must be 2 parties. That's basically what that's saying. Okay? Then there must be a trustee, somebody who has a responsibility for carrying out a duty on behalf of a, here's the 4th party, beneficiary. So you have the grantee or trust, grantee, and let's explain it better because I'm messing it up by adding all of these T's in there. Ladies and gentlemen, it works out this way. You have the creditor and you have the debtor or the borrower. Then you have the trustee. Now for mortgages, it will be like the individual who comes in as the servicer. Okay, those are your 3 parties. There are 3 parties. You have your creditor or the bank, the borrower or the you. Okay, and then we have the trustee or the servicer. Those are 3 parties. Now hold on, there's a 4th party, a beneficiary, somebody who benefits as a result of the trust agreement. So there's a beneficiary. Then there is 2 more elements that we didn't mention. That's 4. Let's add the other 2. That it must be workable. and it must have an expiration date. Expiration date. Those are the 5 elements to a trust. Okay, that's what this paragraph is showing, that there are those 6 elements. Okay, let's continue. There appears to have been an injustice in that despite the court having knowledge of an arbitration agreement and the election of a party, that agreement to proceed before an arbitrator rather than through the court forsook its duties and obligation through its judicial officer in violation of the terms and conditions of the delegation of authority, albeit limited. The judge's delegation of authority is a limited delegation. The judge had no discretion to ignore the wishes of the parties. Supreme Court has already said that. Now, by acting outside the scope of its discretion, the court is acting outside the scope of the protection of the law, i.e., without immunity. The court has no immunity when they violate the law, because there is no protection for violation of the law. Don't care who they be, court, prosecutor, doesn't matter. They ain't got no protection. Okay? Okay. Let's go ahead and take care of the next paragraph. We seek only to have, this is supposed to be an order, not in order. So I'll have to update the document. By the court for the enforcement of the contract. This order will be up, today is the 6th. This order will be up by the 7th. Sorry, can't get it up by the time this video is up with the corrections. You'll just have to go and correct the document. By the court for the enforcement of the contract. Ladies and gentlemen, you're normally supposed to put together your own orders, so we will put together an order. Okay? You're just going to have to be patient. It is not our intent at this time to seek confirmation of the arbitration award, as the statute of limitations has not told. You have a year, according to the Federal Arbitration Act, to seek confirmation of the arbitration award. You do that at your leisure. You don't do that when the court tells you to do it. That is your choice. You have the delegation of authority for choosing when you seek such confirmation. This body has within it the authority, power, and the obligatory duty to see that justice be done. And yet we have found that many would ignore equity and its most adored maxims just to prevent one from being victorious by using the law to their advantage. The matter involved commerce, and we invoked the Federal Arbitration Act, otherwise known as United States Arbitration Law. That is the original name for it. A court has, and this is what we have to do, we have to get rid of that, no business weighing on the merits of a grievance, because the agreement is to submit all grievances, disputes, issues to an arbitration, not merely those which the court will deem meritorious. Wait, doesn't that sound like notorious? Meritorious? Anyway, those of you who understand what I mean by notorious, they understand what I'm doing. Many of y'all ain't gonna get it, but the BIG, and then some people think I'm even talking about the movie Big. Okay, anyway, we also bring to the court's attention that it cannot act outside the scope of the intentions of Congress. Here is the intentions of Congress and what they had to say with regards to its intentions respecting the Arbitration Act. Ladies and gentlemen, what I'm about to read you is exactly what took place when creating the Arbitration Act. Pay attention. By enacting Section 2 of the Arbitration Act, Congress sought generally to promote the enforcement of arbitration agreement. Historically, American courts viewed arbitration with judicial hostility. It is believed that this hostility flowed from a similar enmity displayed in the English courts. Why? Because it took their power away. Arbitration infringed on the livelihood of English judges who were paid fees based on the number of cases they decided. See, this took cases out of the court. English courts were also generally unwilling to surrender their jurisdiction over various disputes. The hostility towards arbitration subsided as industrialization led to the increased number of business disputes. In 1924, the court upheld the New York law that compelled arbitration in a dispute involving a maritime contract. The court's decision in Red Cross Line versus Atlantic Fruit Company is believed to have been the open door for federal legislation that recognized the validity of arbitration agreements. President Calvin Coolidge, another one of them idiots, signed the United States Arbitration Act, commonly referred to as the Federal Arbitration Act. Ladies and gentlemen, it is called the United States Arbitration Act, but they call it the FAA. On February 12, 1925, see, you have Congress and the President. The enactment of the new law declared a national policy favoring arbitration and withdrew the power of states to require a judicial form for the resolution of claims which contracting parties agreed to resolve by arbitration. Need that, because that's being a quote from Congress, from the courts. While Congress's primary motivation for drafting the FAA reflects its interest in protecting the enforcement of arbitration agreements as agreed to by the contracting parties, it also understood the potential benefits that would be provided by the law's enactment. It is practically appropriate that the action should be taken at this time when there is so much agitation against the costliness and delays of litigation. Costliness and delays of litigation. These matters can be largely eliminated by agreement for arbitration if arbitration agreements are made valid and enforceable. Although Section 2 of the FAA requires the enforcement of arbitration agreements in maritime transaction and contracts evidencing a transaction involving commerce, pay attention, that's the quote. It just has to show that it's evidencing commerce, and it's automatically Federal Arbitration Act. The precise scope of the latter group, evidencing commerce, of contracts has not always been certain. Congress provided a definition for the term commerce in Section 1 of FAA, but it did not identify the extent to which the contract must evidence a transaction involving commerce before the FAA would apply. The courts have held the Section 2 phrase involving commerce, and this is the part that you need to understand, people, reach the limits of the congressional commerce right, the congressional commerce powers. What's the limits? Anything involving commerce. In Snyder versus Smith, for example, the United States Court of Appeals for the Seventh Circuit maintained that the courts should take into account Congress's broad power to regulate under the Commerce Clause when deciding which contracts involve commerce. Now look, if the United States get involved in commerce, they waive any sovereign capacity. Pay attention. Because Congress may reach activities affecting interstate commerce under the Commerce Clause authority, the Seventh Circuit reasoned that it was logical to conclude that any contract affecting interstate commerce falls under Section 2 of the FAA. In 1995, the Supreme Court determined that a broad interpretation, and that's what we want, is appropriate. In Allied Bruce Terminex Companies Incorporated versus Dobson, the court held in a 7-2 opinion authored by Justice Breyer that the phrase involving commerce signaled the full exercise of the congressional power of Congress under the Commerce Clause. Ladies and gentlemen, this is what we want, okay? Why? Because this lets you know that if the contract involves commerce, it involves the Federal Arbitration Act, and every state law that deals with arbitration, including the court rules, must yield to the Federal Arbitration Act. That's what the Supreme Court said. The court concluded that the FAA legislative history indicates expansive congressional intent, and that's what the court must go to when interpreting a statute. For example, the House report accompanying the FAA stated that the Act's control over interstate commerce reaches not only the actual physical interstate shipment of goods, but also contracts relating to interstate commerce. Your contracts. You feel me? That's why this is important. Who loves you, baby? Anyway, Kojak, Telly Savalas. Those of you who don't remember Mr. Kojak. In addition, remarks in the congressional record indicate that the FAA affects contracts, and this is why I'm highlighting this, because we are dealing with any contract that relates to interstate subjects or contracts of admiralty. The courts maintained in 20 H.R. 20 House Resolution Report Number 96 Supra, as noted above, 10 at 2.21, see 9 U.S.C. 1, the word involve should be read functionally equivalent to that of affect, that affect interstate commerce. So either it involves or it affects interstate commerce. Because the phrase affecting commerce, gotta bold this too, y'all, normally signals Congress' intent to exercise its Commerce Clause power to its fullest extent, the court reasons that the use of the phrase involving commerce should be given the same connotation. After concluding that the phrase involving commerce should be interpreted broadly, the Dobson Court further determined that the FAA applies to all contracts that involve commerce and does not require the contemplation of interstate commerce connecting a connection to the parties. That's what we want right there, that phrase right there. The court found that the contemplation of the parties requirement is inconsistent with the FAA's basic purpose in helping parties avoid litigation. Such a requirement invited litigation about what was or was not contemplated by the parties. Any congressional recognition of an expedited dispute resolution system at the time the FAA was drafted would be undermined by additional litigation. Now, this is important, so pay attention. Commerce means, what does commerce means? Commerce among the several states, this is actually from the Act, ladies and gentlemen, with foreign nations or in any territory of the United States District of Columbia, between any territory and another, and between any such territory and a state or a foreign nation, or between the District of Columbia, any state or any foreign nation, and you'll see it also talks about persons within this. This is from the Act. Okay, Section 1 of the FAA. We include this information as a basis for the preponderance of evidence to the contrary of any claim that the matter does not involve commerce, and that the contract between the parties do not involve commerce, and that the arbitration agreement does not incorporate such issues, including the attachment of the Federal Arbitration Act and the intentions of Congress when enacting such an act. This is a matter of equity, dealing with a contractual trust relationship, and is subject to the rules, principles, and standards of equity. The Federal Arbitration Act is an equitable statute in that it requires an agreement of all parties. The contract with an arbitration clause is determination or documentation of the agreement of all parties. The Supreme Court decision in Henry Schein Incorporated versus Archer and White Sales, the court held that such contracts to include issues of viability, validity, and dispute controversies and or issues are to be resolved before an arbitrator when the contract and arbitration agreement so dictate. In this very instance, the contract makes such dictation. Remedy sought. The contract requires certain performances on the part of the opposing party, including the return of properties. So long as the properties have not been returned, this is a violation of the right to property, a constitutional sanctioned and secured right. Interest and other assessment accumulated. We ask that this body issue an order to the opposing parties for compliance with the agreement for the return of all properties and making the complainant whole by reversing the acts and or actions of the respondents related to this matter, and for an injunction against the opposing party from acting outside the scope of the agreement, confirming the award is not sought at this time, that it is a separate process, and we shall utilize our right to that remedy before the tolling of the statute. I put before this court that I am attesting that I have attained the age of majority, that I am over the age of 18, am competent to handle my own affairs, and am attempting to gain control of the securities held in my minor account. But the custodian and others are colluding and attempting to prevent me from gaining access to my property in violation of my due process rights as outlined and stipulated within the framework of the Bill of Rights, specifically the Fifth Amendment to the United States Constitution. we're going to change this, ladies and gentlemen, because y'all know I don't like that United States coming first. It's United States comes last, y'all. The people come first. Okay, I am seeking to redress this issue. I am seeking equity. So I present this bill in equity to the court and do so as grantor or trustor over the estate of the minor infant. I do hereby say that this is accurate and presented on this on such as such on this 23rd day of March 2019. And that's the end of the document. You sign it as, never sign your name and just leave your name. Put who you is. Okay, you the grantor. All right, and that's this, a bill in equity for the enforcement of a contract. Ladies and gentlemen, I hope that this provides some benefit to you. And the next video will provide even more. Have a good day, have a good life, have a good night. Look at that, 46 minutes. That's a shame. Goodbye.